thank you for those kind words. It's a great privilege to be here, if that thing doesn't hang me before the end of the talk. And it's a great occasion to share some of the most advanced, most recent thought on a topic of some importance for the philosophy of history, for the philosophy of law, and for political thought and practice, which is the issue of how to make nonviolence effective in a world, in particular in the Middle East, that is governed mostly by the extraordinary violence that we've been seeing increasing in recent years. So the talk that I'm giving is part of this larger framework of research that has landed in that book. And so I thought, in order to put the more detailed elements of the talk in perspective, that I would tell you a bit about the structure of the book, so that you can see where that particular strand of thought, that is the Middle East challenge toward constitutionalism, operates. So the book is divided in three parts mostly, and the three parts are actually moments of historic change, a moment which initially is revolutionary and that we have seen developing in those extraordinary marches in 2011 across the Middle East. And I tried to understand the impulse behind that formidable feature, particularly at the beginning of the revolution, that people, including places as quote-unquote backward as Yemen, would march in their millions to remove a dictatorship while consciously asking for the revolution not to be bloody. And so this is, I think, a great, intriguing question of our age, and the book tries to make sense of it. It also shows that oftentimes the street is way ahead of what politicians or self-anointed leaders tend to think, and certainly academics tend to lag behind. And the book is, in a way, an answer to that surprise, quote-unquote, that took the world into its grips when the first demonstrations against Ben Ali in Tunisia took place in late December, and then were carried through across the region, resulting in no less than 4 removals of dictators. 3 of them were by what I call almost absolute nonviolence. That is, violence is of course exerted by the dictatorship, by the government, and indeed without this, the revolution itself could not be nonviolent. But the revolutionaries consciously adopt a policy of not shedding blood, are particularly careful about the message and the practice, and succeed thereby in a rather formidable process of change, as we saw in the case of the defeat of 30, 40-year-long dictatorships like the ones we had in Egypt, Tunisia, and the Yemen. And of course, the failures of other places where, for instance, in Syria, the revolution was absolutely nonviolent for the 5 months. We're celebrating today, I think, the 4th anniversary of the Syrian revolution, which has turned extremely sour. And one of the questions that are raised in the book is whether the turn to violence in the summer of 2011 in Syria was not what the dictator of Syria was actually asking for, working for, and how this played right into his hand to transform a very strong movement into essentially an extremely ugly civil war. So beyond that chapter that draws the lines of the Middle East revolution that we've witnessed in 2011 and try to make sense of the nonviolent dimension of it, there are another 2 chapters in that part. One which looks at the much deeper cultural baggage of nonviolence through a number of examples that I take from the great poets of the Middle East, most particularly Mutanabbi and Abu al-Ala al-Ma'arri in the 11th century. And so there are extraordinary texts of their vision of nonviolence. You will be really surprised to discover them with me. But also on the historiography of Islam and the Middle East in a way that Timothy Garton Ash described once as an unviolent narrative, through to the modern period. Of course, that chapter is quite selective and tries to embrace far more than it can possibly, but it gives also pointers for further research, which I think is necessary to understand what happened in 2011 and to understand the future, the possibilities of the future of nonviolence as the nexus of the philosophy of history in the years to come. And the third chapter is far more withdrawn from the Middle East, in fact has very little to do with the Middle East, because it posits a central argument in the book. And through a rereading of Kant's treatise on perpetual peace, which I'm sure most of you are familiar with, and that is the conception of a world where there is no war, in a genre actually that I tried to discover through Kant, going back to the Peace of Utrecht in 1712, and of a theoretician of the Peace of Utrecht, who is of course far less known than Kant, but who is at the origin of this genre of perpetual peace. When you think of it, it's a bizarre word, perpetual peace, but it has its roots in that treatise of the Abbé de Saint-Pierre, who was a negotiator at Utrecht and who tried to conceptualize a way to persist with the peace beyond local ceasefire that wars tend to be generally in history. And so that's taken up by Rousseau in commentaries on the projet of the Abbé, and then afterwards in Kant. And I do think that Kant is still, as you well know, the thinker of the democratic peace theory, under which democratic countries do not go to war against each other. A very powerful statement of international relations, which is still as lively as it is when the great philosopher of Königsberg put those thoughts on paper at the end of the 18th century. Now, that in itself is not particularly original. The attempt at originality in this chapter is to juxtapose the Kantian thesis, where democracies don't go to war against each other in the international field, with a major paradox that I ascribe in its latest iteration to a well-known jurist of Yale Law School. He is far less known abroad. I'm sure people like Matthias will be very familiar with his thought. It's Robert Cover, who wrote the last year, he died young in 1986, who wrote in Violence and the Word a very fine article, stylistically as well as substantially, where the main idea is one that develops from Max Weber's, of course, well-known equation of the monopoly of violence with the state, but he does it in a slightly more refined way, as it were, by suggesting that we should not kid ourselves, that the greatest image of our democratic society is the judge, and that as a consequence we shouldn't kid ourselves because judges, in his words, deal pain and death every day. In other words, that without force at their behest, judges are simply unable to establish the rule of law, in particular and including in a democratic society. So you see the paradox of a world with no violence because countries are democratic, but democracy being based, whether we want it or not, on an understanding of violence which is associated with the necessary function of judging, including and in particular in democratic societies. I don't think I gave an answer to the paradox, but I propose at least one way forward, and that one way forward links in with the second part of the book, and that is we have to accept that revolutions can be absolutely nonviolent. And we have the evidence of this, a number of extraordinary revolutions in the modern age, including the fall of the Berlin Wall, and the 2000 Middle East revolution known as the Arab Spring, that you can have an absolutely non-violent movement that removes the dictatorship, but that the revolutionaries thereafter, in other words, when they're inevitably organizing their government in the wake of the collapse of the dictator, cannot avoid the use of violence, because violence becomes associated with the iconic figure of the judge. You cannot have a democratic society, you cannot have the rule of law as understood in a liberal manner without having the judges implementing violence, actually relying on implementation of violence by the other apparatus of the state, most particularly the police. And so we have this paradox where the only moment in a philosophy of history where non-violence is absolutely, pristinely, holistically possible is during a revolution. But once the revolution has achieved its goal of removing the hated regime of violence that has presided over the lives of citizens for 10, 15, 30, 40 years, then it has no choice but to organize thereafter society in ways where violence becomes a normal part of the rule of law, naturally arbitrated differently than in dictatorships, but nonetheless one where this absoluteness of nonviolence that is concomitant with those extraordinary revolutions for a short period of time is one that becomes unsustainable thereafter. So that actually compels us into going in a theory of nonviolence, or more ambitiously in my case, at least in my hopes, is to offer a philosophy of history where nonviolence becomes the nexus of change, very much against, as you well know, that famous sentence associated with Karl Marx that violence has always been in history, the midwife of change, the midwife of history. So nonviolence as the midwife of history is a phenomenon which puts into question really the whole philosophy of history as we understood it. And think of it, when we talk about revolutions, it's rare that we don't think that there are violent revolutions. What we have to adjust to nowadays, after all that's happening in Eastern Europe, in Ukraine, in Tiananmen, in the collapse of the Eastern European countries in 1989, and in the most violent region on earth, the Middle East, since 2011, that there is something there that is quite challenging to our received notions that revolutions operate always violently, and two, that the philosophy of history, that is the philosophy of fundamental change, is one that operates with violence as its condition, revelator, or implement. So once we move into that second phase, we move into what my great colleague Bruce Ackerman calls the constitutional moment. Inevitably, after the collapse of a dictatorship, people are looking for a new social contract that we call a constitution, and the question becomes, if we take it for granted that violence is back in the fold, what is it that will allow that social contract to operate with rules that prevent people, to the extent possible, of seeking their political interests in shedding the blood of others? And when you think of it, a working constitution is one that should prevent that. So there is a moment in the philosophy of history where the constitution becomes the natural successor. The working constitution, of course, becomes the natural successor of a non-violent revolution. Now, of course, constitutions also follow violent revolutions most often. So the question becomes a bit more difficult to articulate fully, but that's what I try to do in the second part of the book, of which the lecture today will give you a slightly more precise dimension, which I tied in order to fit well with the series, the comparative series that we have organized, to see what is particularly Middle Eastern in the conception of a constitution which brings a modicum of peace that relies least on violence in the advancement of political interests and ambitions of individuals and groups in a post-dictatorship society. So the focus is mostly on this, but let me say just 30 seconds of summary of the third part, in the same way as a philosophy of history that develops from a nonviolent revolution into a constitution that works, operates on two sides of the same continuum. In other words, for previous theories of nonviolence, as I mostly read them, that the second part is an integral part of the nonviolence ethos, and that it doesn't merely stop when the dictator is sent packing or is put in jail. In the same way as there is this second constitutional moment, inevitably an integrated philosophy of nonviolence, there is a third one, and the third one I call justice, but justice in the sense not so much of a very much more general concept of justice, Rawls-like or Amartya Sen-like, but one which is essentially vesting in the judicial accountability of the dictator and his main aides. In essence, actually, the accountability that the quote-unquote new society, post-dictatorship, is trying to deal with the past that it's trying to exonerate, to understand, and to remedy. And usually, the most striking dimension of it is a judicial accountability, and that is to bring the collapsed or the former dictator, if you can get hold of him, to trial. And so in the same way as there is a necessary second moment, which is constitutional, there is by necessity a third moment, which is judicial. And so the third part looks at the history of what I call, research as crimes against humanity. So you have a chapter on how it came about in the French Revolution, actually, with the trial of Louis XVI in 1792, 1793. So it's a little discovery of mine that this is associated, that is the equation of the tyrant, the dictator, with the crime against humanity, in a famous speech that Robespierre says on the occasion of the trial of Louis XVI. And it goes on, and I discovered actually very enticing examples of interest to Middle Easterners in the trials in 1860 in Syria and Lebanon, in the wake of atrocities committed, and trials for which we have a record, and that record I'm trying to understand in the concepts which are obviously far more developed now in international criminal law. So that part is the third part. It's quite extensive, but it's also very much part. It's a very much of the essence, I think, of a philosophy of nonviolence, hence the book. Now, returning to that part about constitutionalism, it's quite developed. It suggests that we are still under the spell of what the Atlantic Revolution, as great historians have renamed what happened on both sides of the Atlantic between circa 1770 and 1820. It is a series of upheavals that are animated by a similar spirit. And rather than look at the American Revolution on its own, or what happened in the Netherlands, or what happened in Germany, or in France, of course, those great historians, mostly Jacques Gauchot and Robert Palmer in the 1950s, started talking about the Atlantic Revolution. I think the Middle East Revolution is very much like this, so it would be a big mistake to give up now. It is a phenomenon which is going to be spreading at least over a generation. It's a fundamental upheaval that is taking place. There are setbacks and advances, but certainly a phenomenon for which that is indicative that the history in our assessment of what's happening in the Middle East is still young. All right, so within that Atlantic Revolution, there's a fundamental constitutional revolution also that is taking place in the realm of ideas, and the names of the great conceivers of a different way to run the country than by the word of divine law bestowed upon a sovereign who is the mouthpiece of God on earth. It is the people who come in to take over the sovereignty, and who, in the words of Rousseau, are the ones that are going to give legitimacy to the law in a social contract. We call it the Constitution, and of course it takes the shape of an extraordinary debate that takes place with the founding fathers in the Federalist Papers and otherwise around the American Constitution in the 1780s, but then carries forward with the Constitution of France, the Constitution of Poland in 1791, and the various attempts that are taking place elsewhere in the continent, but also in places like Haiti, where the revolution of Toussaint Louverture is one which is clearly within that realm of the constitutional upheaval in the wake of the collapse of the Ancien Regime. Now, this I proposed in the book, we reduced to an acronym. I'm going to be very quick, otherwise it's going to take most of the talk, and Dr. Berian will be very impatient. And so I call it LEGFARC. All right, so have a guess. LEGFARC is L for legislative, E for executive, J for the judiciary, F, and it's in parentheses, is for federalism, A is for amendments, R is for ratification, and C is for citizens' right, as in the Bill of Rights. Well, look at those 7 titles. Plus and minus federalism, because you don't necessarily have a federal constitution for a constitution to be democratic in the Atlantic Revolution. And since, give or take the federal dimension, no one has added anything else to this since the Atlantic Revolution in the late 1700s. And so this model, this concept of LEGFARC is the constitutional calc under which any constitution that you're going to write, and that's why people say you can write a constitution in an hour. Indeed, you take the 7 main articles or chapters and you fill them up. How do you get your legislative elected? What is the exact role? How do you make a law? You take the executive, it's in charge of applying the law. How do you elect the executive and so forth? The judiciary, what's their function, is to make sure that the system works. Federalism, if you have a system of states like in Switzerland or Germany or the United States, what's the autonomy? What's the relative sovereignty? How can the unity work? And then amendments, ratification are easy, inevitable. They tend to be not that important, but you need them in the Constitution. And then, of course, very importantly, you have citizens' rights, the Bill of Rights, which you will find in any constitution if you were to construct one. So I said, that's it. That is the constitutional imagination. And frankly, since then, we have not added a single iota, a single comma. We have just filled up those boxes of LEGFARC. And we're still with it. If you were to write a constitution for Tunisia today, or a constitution for Egypt, or China, or Burma, you have to go through the 6 or 7 chapters and decide whether you want it to be a federalist or not. But in the whole, the specificities of each country remain within a realm of variations that is relatively unimportant. And so our constitutional imagination, I suggest in the book, is dull. It is very difficult. We can't have a eureka moment in constitutionalism. The mold is there and has not changed significantly since it was put together by Montesquieu and his colleagues in the second half of the 18th century. And so we come to the Middle East, and we are confronted with the necessity in moment 2 to have a constitution, a new social contract, and we're confronted with this Leschfark. There is no way out of the Leschfark, except that there is something a bit special in the Middle East, and that is the subject of part of my talk, at least today. Part of my talk, because I would like to start with something that will be, I think, far more familiar to you, that is to you, comparative constitutionalists or people who are not necessarily versed in what happens specifically in the cultural realm of the Middle East, and that is, you need a judge, right? You can't have a constitution without a judge, and if you want the judge to perform, then you better give her and her colleagues the tools to be effective against a background where judgeship has always been controversial, because remember, a judge is opining on laws, but is also opining on constitutional matters, where if L and E, that is the legislature and the executive, are falling foul of the Constitution, it is the judge, even if they have 99% of the votes, who is going to tell them, I'm sorry, your law doesn't go, your decree doesn't pass, because it is in contradiction with the Constitution. Right? So that's a very major problem of judicial theory, under what order of authorities, the level of orders that Professor Matthias Mannmann has written about eloquently, under that, what order is the judge vested with telling the people who have elected their legislative representatives and their executive representatives to go packing because they run afoul a text that is called the Constitution. And so we have to devise this, and this is where the mold is yet not quite gelled. And let me start with this. So there'll be 3 parts to the talk, and I'll probably have to summarize some of it. And that first part is, well, come to the Constitution table, and you're starting afresh with a revolution, wonderful nonviolent revolution, backing you, and you want to protect that Constitution that you are writing. And the only protection, or the main protection, of course, is going to be through the political process, elections, the recurrence of elections, and so forth. But if you have a problem, we need an arbiter. We need someone who will say that there is dysfunction, different interpretations, and he, she, the judge, is going to tell the other powers that her interpretation is going to be the one that is going to be binding. We're familiar with that, but let's think of it slightly differently. If we were to write up that part of the Constitution about judgeship, how do we conceive of it in the Middle East, and I think anywhere else, actually. So as jurists, we hardly forget that the ultimate interpretation lies with the judge in both the Middle Eastern and Western traditions. The rules are finite and cases infinite. النصوص, that's for you, Beatrice. النصوص معدودة والحوادث ممدودة. Cases are finite. Rules are finite and cases are infinite. This is from Sarakhsi, one of my preferred Islamic jurists. He died in 1090. It is said that he shouted the 30 volumes of his Mabsut through a well where he had been imprisoned by the ruler for doing something that the ruler didn't like. I like to say this to my students because it's just a wonderful idea when you look at the 30 volumes. And I can tell you very few people in the world have read the 30 volumes, so imagine shouting them out of the well. Well, in one of the texts we have this extraordinary, profound, rules are finite and cases infinite. And it's the judge who is going to interpret the rules. The judge is not a luxury in a constitution. So following Sarakhsi, let's examine first how to see that judges be best equipped to solve cases infinite in general terms, then how we can address the specific sectarian deadlock that is the key riddle of Middle Eastern constitutionalism as I will present it to you. So from the formal perspective defended in this little acronym, LEJFARC, the Enlightenment remains king in constitution making as a collection of a text serving equal citizens. The Constitution posits no privileged group and no discrimination between citizens. Nothing can defeat the principle of equality. The departing point is that groups have no place in the Constitution, whether they are religious, gender-based, or defined by short stock build or blue eyes. Secularism, also known as the separation of church and state, emerges as the logical consequence of the principle of non-discrimination, of which religion is a subfield. The interaction between state and religion, even in the West, is far more complicated, but the principle is secularism as the religious expression of citizens' equality, and the exception, a tainting of the state and its governmental apparatus and laws by religion. In contrast, the constitutional voice that comes loudest as a Middle Eastern challenge to the received scheme is religious. To summarize, the religious dissonance is expressed in two main forms. The first dissonance comes in the supra-constitutionality of Islamic law, or the forced reference to Islamic law as the source of legislation. So I discuss it in the book under the Article 2 template, and you'll be very familiar, for those of you who know about constitution in the Middle East, the famous Article 2 of the Egyptian constitution that says no laws shall be passed that will be in contradiction with Islamic law or with Islam. All right, and a change over the original text that was passed in 1970, so we're talking about the former constitution, where A is replaced by the, thereby giving Islamic law the exclusive or the dominant dimension in the ordainment of the constitutional text. So this I'm not going to talk about today. I deal with it in the text, and I hope you'll find some novelty in this, because it's a debate that has been going on now for 30 years, and there's very little one can add that is novel to it. So I suggest a way to overcome the dissonance through the referencing or incorporation of Middle Eastern legal traditions with a natural privileging of the Islamic corpus on its own merits of excellence and the constructive incorporation of the legal tradition as a matter of style. So to make it less abstract, the idea is we need to use our own language when we write the Constitution and not translate from the West. And since there is the extraordinary legal corpus, particularly Islamic, not only Islamic, but particularly in Islamic in the Middle East, better to look to the tradition for expressing constitutionalism than borrow the interpretation and the translation of foreign text with which local culture is not particularly comfortable. Now, I'd like to add with you tonight some aspects of judicial review as a citizen's protection, first in general terms, then in the particular sectarian field. On the general role of courts, global constitutionalism has much to say. Middle Eastern constitutional adjustments to the rise of the constitutional courts run a full gamut of possibilities, from the prohibition of the reference to the Constitution by any judge to the constitutional judge's significant presence in political life. On one end of the spectrum, the argument can be advanced that courts have no constitutional role whatsoever. In Gaddafi's Libya, despite a formal act passed in 1994, or in the constitution of Syria under the Ba'ath, any such reference was just ignored. There is no constitutional judge. In Kuwait, the Constitutional Court traditionally shied away from getting involved in any controversial matter. This is generally also the case across the Gulf states. Even in countries where a semblance of democracy were respected, the old French and Westminster-style constitutions that consider Parliament sovereign and its laws immune from any form of review by a non-elected body remain the default principle. Typically, a specific clause in the Code of Civil Procedure prevents ordinary courts from referring to the Constitution. On the other hand, there was, at least on paper, and in some instances in reality, a full-fledged constitutional review by courts, even on the lower level. This is the case, for instance, of the United Arab Emirates, incidentally also leading to refreshing readings of classical Islamic law in some current cases, and in Yemen between 1990 and 1994. In unified Yemen, the Constitution of 1990 gave broad powers of constitutional review to the Supreme Court, and there are traces, before the collapse of the country into civil war in 1994, of a hesitant but real effort to make judicial independence a reality. That effort did not survive the war of the North against the South and the subsequent dictatorial entrenchment of the ruling republic turns monarchy on the side. So two models of judicial review, roughly, have emerged in the modern Middle East, which I described elsewhere in a book that I published in 2007 called Introduction to Middle Eastern Law, for those of you who are interested. So there's a lot of the discussion of those constitutional cases in the Middle East since the 1950s. But there are essentially two models. One model follows the French Constitutional Council, the Conseil Constitutionnel. The other model follows the US-style Supreme Court. In the first judicial review category, that is the one following the Constitutional Council model, the French model, stood Iran, and continues to stand, where the Council of Guardians, which is similarly court, had, like in France, a short period during which legislation passed by Parliament was subjected to constitutional review. Other countries stuck even more closely to the French Conseil Constitutionnel model, namely a small group of parliamentarians being able to challenge, but only during a short time, a law that was passed by Parliament and promulgated by the executive, be that executive a king or a president. This was adopted in former French colonies, most conspicuously Lebanon and the North African countries west of Libya. So you have Conseil Constitutionnel across the North Africa, Algeria, Morocco, Tunisia. That's even before the revolution. In the second category stood the Egyptian Supreme Constitutional Court. Unlike the US Supreme Court, it was a court of referral. In other words, it was a court of exception. If there was a case that was coming before an ordinary court that had an element on it which had a constitutional dimension, that court, that ordinary court, could not rule in the matter, but it could stop its deliberations and refer the case, because of its constitutional dimension, to the Supreme Constitutional Court, and then it was bound by the decision that the Supreme Constitutional Court had emitted in this particular case. So instead of lower courts having constitutional writ going on to appeal and then eventual review as in the United States, the SCC, the Supreme Constitutional Court of Egypt, would look into the constitutionality of a statute upon a referral by a lower court on the occasion of a constitutional dispute affecting the aggrieved citizen as party. The lower court itself, or the Court of Appeals, did not have such power. So in the large literature on constitutional courts in the world, we have pros and cons for each country. This is not only Middle Eastern, you're going to have it across the spectrum of systems that follow traditionally the French Constitutional Council, especially, well, until now, because its constitution writ, although there was an amendment 4 years ago to allow a normal decision to go eventually to the Constitutional Council for the review of its constitutionality, it's still a very limited number of essentially 60 senators or members of parliament who could, within 15 days of the promulgation of the law, bring it to the Constitutional Council to decide whether it was consonant with the French Constitution. So whether you have this system or the American system, where everything goes for constitutionality for all courts, and then the apex is the US Supreme Court, they all occasion recurrent doubt for the fact that a group of unelected judges is capable of telling Parliament and the executive, both elected by majority vote in universal suffrage, that parts of the statute or decision they have passed are unconstitutional. For critics of constitutional review, the least dangerous branch turns suddenly into the most powerful one and substitutes its final binding decision for the will of the people as expressed in legislation or in executive measures. So one really can hardly be original in a debate that spans the full course of 200 years since the Atlantic Revolution's constitutional beginning, but I will present very briefly a three-point advocacy, and I'll leave it at 3 points because I'd like to talk about something which will be, I think, of more interest to you. So a three-point advocacy in how the shape of judicial review may be best approached, at least from my perspective, when we are writing new constitutions for post-dictatorships in the Middle East. Namely, one, that courts in the judicial system be unified in a hierarchy with one Supreme Court. Two, that all courts have the power of constitutional review. And three, that the judiciary is exclusively attentive in the exercise of its constitutional power to the plea of the person individually or as part of a historically subordinated group, rather than adjudicate the disputes between politicians belonging to different branches of government. I'm not going to dwell on this. I'll say just a few words for the three, just to give you the sense, because I'm sure you will relate to that controversy by being in utter disagreement with many of the points that I'm going to say. The argument is that we need one Supreme Court and the judicial unified system. So the French, as you know, has the Conseil d'Etat and the Court of Cassation, plus they have the Constitutional Council. And many countries in the Middle East have followed, and outside the Middle East. My sense is that does not serve best justice, because there is an uncertainty in the rule of law when there is no unifying system, at least at the top, that puts for the citizen in order that extraordinary array of different courts. Some of it can be commercial, some of it be administrative, some have to do with fiscal matters, some have a more constitutional flavor with the basic protection of the citizens, some are criminal. All of this, unless it is unified into one judicial order at the top of which sits a Supreme Court that allows the citizen to see more clearly into the one rule of law that he or she is subjected to, I think there are flaws in the system that will perpetuate this. So that's one necessary point in the structure of the judiciary which I'm advocating. Then I'm advocating that all courts have the power of constitutional review. So I'm essentially advocating for the American system. Now I remember there was a seminar in Heidelberg where my good old friend, the Iraqi Chief Justice, as he likes to call himself, but is actually the President of the Supreme Court of Iraq. Again, they have a problem in Iraq, because the administrative courts are separate. And the Court of Cassation is one which is not quite the court that is allowed to look into constitutional review. He said, but doctor, if every single court is going to look into the constitutional review, I'm going to have 27 million cases every day in Iraq, and 27 million being the number of inhabitants in Iraq. In other words, there's no way that the courts can deal with such an extraordinary docket of people using the Constitution to say that their rights have been aggrieved and impaired because the neighbor has stepped on their plant over the balcony, and because the police has been harsh in the treatment of the neighborhood suspect. Still, I would say that, in fact, judges are not stupid, and the citizens are wise. There is, in the same way as there is a problem of dockets, anybody can be litigious. In a society, you can go to the court as a matter of right for access to justice. It's a principle. The system has a way to balance itself out so that you don't have the weight of the constitutional review preventing any progress in the adjudication of the citizens' rights. Of course, that's controversial, but that's an argument that I'm sure that Haj Mahmoud is still in disagreement with me over. And the third is a little bit more subtle, and it comes mostly from the discussions about constitutional review in the United States. And my argument is that if you want to protect the strength of the courts in constitutional matters, you have to avoid as much as possible to subject them to the political nature of controversy. And by political nature, I'm not saying that you have to understand any problem that arises as a political one. Of course, at some level of abstractions, all cases and controversies are political, especially if they reach the court. But more of the sense that you have political groups, particularly institutions, that are strong enough to advocate politically for the resolution of a problem rather than to turn to the court to solve it. The basic case for me is the failure of the Supreme Court in the United States to adjudicate the problem between Bush and Gore back in 2000. It split down the middle of the Republican Democratic Party. So the question is, how do you devise a system where the main thrust of the work of the court is going to be adjudicating matters that deal with citizens or groups, particularly citizens or groups that institutionally do not have enough of a voice in the political system, say Congress or the White House. They are powerful enough as agents to be able to defend themselves, and if there's a deadlock, well, I think the political process is far more habilitated to solve the deadlock than to turn to the court for constitutional adjudication. So these are 3 points which I think belong to the world of comparative constitutionalism, irrespective of the Middle East. So let me now turn, and this is actually choking me, so can you do something about it? I feel like an albatross. Thank you. So I'll raise my voice. I have tended to be a lawyer occasionally in my life, so to attract the attention of the judge, I can speak loud enough.
I just walk a bit around it, don't worry. A, this works.
It does.
And B, I'm not sure. It doesn't strangle me. Can I give it another try? Perhaps it was long.
I'd rather lose my voice than lose my neck. Thank you, Professor. All right, so the second section, and I think we'll have to stick to the second section, Dr. Berian, I'm sorry. The presentation of the book has taken too long. Is about religion, sects, subordination, and federalism. So the most vexing constitutional challenge of the religious Middle East arises from the effects of the dominant religious sect on minorities, also defined religiously. Muslims versus non-Muslims, Muslims vis-à-vis other Muslims belonging to a different sect, mostly Sunnis versus Shi'is, but also Druze, Alawis, Baha'is. As part of the Atlantic Revolution's constitutional acquis, a Middle East citizen relates to the state directly. That's what all citizens relate to the state anywhere in the world. This is common to East and West. But he or she also relates to the state, whether she or he wants it or not, as a member of a self-sufficient mediating entity, the religious community or sect into which that person is born. Citizens are Christian, Muslim, Jewish, etc., whether they want it or not. The religious logic regularly falls prey to its own sectarian logic, which then focuses on the subset of a given religion. As Muslims, citizens quickly divide into Sunni and Shi'i, a deep sociological, political, and this is important, constitutional fracture in the Middle East. As Christians, they are Coptic in Egypt, Maronite versus Orthodox in Lebanon. As Jews in Israel, they may belong to a reformist or conservative denomination, but more important, they stand in a superior constitutional position over the non-Jewish citizens. We're all waiting for the result of the Israeli elections, of which the most important dimension after 70 years is what is going to happen to the Arab-Palestinian vote, that is, the non-Jewish vote in Israel. The atheist, non-believer, non-religiously denominated citizen does not exist in the eye of Middle Eastern constitutionalism. This fracture, ladies and gentlemen, is sociologically and theologically unbridgeable. It may be a great source of diversity, but such mismanaged diversity is the nightmare of the Middle East because there is no time-honed constitutional solution to communities and sects locked into demands that can simply not all be accommodated. Some countries are luckier than others. In Tunisia, almost all the population is linguistically Arab and religiously Sunni. Much easier to have a constitution for all in Tunisia than in neighboring Egypt or in Iraq or in Syria. But the current coherence of Tunisia is not a stable one historically, and its Jewish community all but disappeared in the course of 2 generations, facilitating perhaps constitutional stability prima facie, but vastly impoverishing the country in the process. Even in Tunisia, come to think of it, the logic of sectarianism remains pervasive and gets transferred to the secular religious divide, with the main political fracture taking the shape of a contest between Islamists and secularists. This may not be totally new to constitutionalism. The state-church separation continues to be a point of contention in other societies. The fracture, though, is different in the Middle East because the religious community is an agency that is not necessarily a conscious political expression, for its constitutional status is not akin to evangelicals in the US Bible Belt, Catholics in Ireland, militant Orthodox churchgoers in Greece or Russia, or the Indian BJP on its sectarian Hindu rise in the 1990s. In the Middle East, the citizen cannot escape the agency of her sectarian group in constitutional terms. So here rests the Middle Eastern challenge to world constitutionalism. The sectarian system, Arabic Ta'ifi, also translated in English as communitarian, religious, communal. The sect is a constitutional agent. The Middle East is a world of communities / minorities sharing a space called the modern state, which is partly the arbitrary result of colonial powers drawing lines in the sand, a trait it shares with emancipated colonies across the European invention of the nation state as Utrecht and concomitantly in international law. If you allow me, I'll digress a little bit because it's another contention of the book that we usually refer to this as the Westphalian nation system. My suggestion in the book, and I leave it to you to discover whether I made the argument convincingly enough, is that the system of nation state as we know it, and to which we refer as Westphalian, actually emerged in Utrecht and not in Westphalia. I'll leave it at that. The arbitrariness is not all European-made. Modern boundaries were also defined by the Middle East's own long wars between pre-modern empires, notably the understudied 4-century-long conflict between Shia Iran, the historic Persia, and the Sunni Ottomans to its west, and to its east, Sunni Afghanistan and Pakistan, and the India-centered Sunni Mughal Empire. The fluctuating, warring lines of Shiism and Sunnism were dictated primarily by religious sect turned political expression, leaving minorities stranded near the shifting boundaries and beyond, in an allegory best captured in the eerie atmosphere of Julien Grac's magic novel, Le Rivage des Sirtes, a manuscript which I discovered dating from 1743 in Najaf offers a powerful insight into the subtleties of sectarian markers between Sunnis and Shi'is against all efforts by the then conquering Nadir Shah to overcome the divide. You see, the Shah, Nadir Shah, an adventurous but a powerful military man, took over Iraq, and he found himself with Sunni ulama and Shia ulama who don't speak to each other. So he forced them into conclave at Najaf and decided, under the threat of death, that they better come to an agreement or else. And so they came to an agreement. But when you read the manuscript, which is the manuscript left by one of the participants in that extraordinary event in 1743, you realize how both the Sunni and the Shia ulama kept with very subtle references to their own sect in ways that Nadir Shah could not detect. And so even though they were forced into this conclave and came out and everybody was happy, it was very clear to those who participate in the conclave, and the author of that manuscript, Abdullah Suwaidi, shows how, for instance, in the way of praying or in the way of talking about Caliph Umar, which, as you know, for Shi'is is one of the unpalatable characters in the history because of the dispute of the succession of Ali. Well, they continued to curse Umar, but Nadir Shah couldn't detect how the curse was about. Why? Because, as in Arabic, they nawwana Umar. In other words, they gave to Umar a declension at the end, which a Sunni would never give. So that was a way of humiliating, of the Shi'is humiliating the Sunnis by reading the name of Umar in a way that would be anathema to the Sunni alim. So you see, we're not out of the woods. One cannot wish constitutional sectarianism away. In terms of nation-state, it's true that the religious divide is shared in Brodel-like longue durée with the Catholic, Protestant, Orthodox fractures in Europe, which explains major current boundaries still, remember Utrecht, at a time when the religious expression has been significantly muted constitutionally and sociologically across the Atlantic world. Sectarian divide continues to be lived dramatically in the other historic divide of Western Christianity in the Balkans between Catholics and Orthodox. And so Serbia and Croatia are not conceivable as independent state without that key sectarian component. Nor is the Ottoman old divide between Christianity and Islam absent from the long Balkan memory. Still, in the West, including across the length of the European Union, sectarianism is peripheral to the constitution. Even in the Balkans, an attenuated sectarianism interacts awkwardly with national and linguistic divides. But in the Middle East, sectarianism is at the center of the constitutional picture, projecting itself onto the world scene in sundry and sometimes unfathomable ways. So one example is that at one point in Latin America, there was sort of a no law zone between Uruguay and between Paraguay, Brazil, and Argentina, I think, I can't remember. But that was populated suddenly by a number of Middle Eastern Shi'is. So suddenly in Latin America, you have an expression of the Middle East happening in communities. Of course, they didn't get a constitution or a state, but for 2-3 years, there was an area which was in effect controlled or lived through the prism of the Shi'i community of the Middle East. Buffeted by the revolution of 2011 and its aftermath, the territorial nation state of the Middle East remains a harsh and pervasive reality. So how can constitutionalism solve this dualism between the individual being an individual relating directly to the state and the individual being a forced member of a community which is also operating as the agent for that individual towards the state? I started the discussion by pointing out the potential role of the constitutional courts in the protection of subordinated groups. Because constitutional courts are a novelty in the region, there is little case law that can be built on where a subordinated group as such finds solace in judicial review. The dearth of case law in the matter does not necessarily mean that the horizons are shut to a corrective judicial rule. Nonviolence, after the Middle East Revolution, inscribes in its constitutional expectations the duty of courts to protect subordinated groups. That debate is bound to persist and to build on both comparative constitutional law and on the Middle East tradition, where the departing point is the Code of Hammurabi's emphasis that law is first and foremost meant, and I'm quoting Hammurabi, law is meant to protect the weak from the strong. This principle, which appears so general as to defy application in the real world, may not prove so elusive if the judge is entrusted with the protection of the weaker individual in constitutional matters, in particular the individual who is part of a group that has been subordinated historically by the majority. This chiefly includes women and sectarian groups. Now, the particularity of women as a group or as a minority is an issue of worldwide difficulty. Women are a constructed minority, not a numerical one, in the Middle East or elsewhere, and they're generally protected constitutionally by the equality clause when it comes to voting. In theory, therefore, women are capable of mustering enough votes to make their voices clear and decisive. The practice, of course, is very different. Rights of women in the Middle East pertain to the religious tradition's most sensitive manifestations, and all three dominant monotheistic religions have historically considered women subaltern, subordinate to men, at best separate but equal. Although there's nothing Middle Eastern in this subordination, the alignment to the standards set by international law, most iconically the 1981 Convention on the Elimination of Discrimination Against Women, is one way of confronting de facto and de jure inequality. A thick understanding of equality is necessary to ensure women's constitutional rights, and constitution drafters can be and have been innovative in this regard at the various levels where the terrain of gender equality plays out, chiefly representation in government, enhanced rights during and after marital life, and inheritance. The sectarian issue, as opposed to the gender issue, is more trying. And in over 2 decades of thinking the issue through, I cannot find an adequate constitutional answer. There are moments of national unity where the citizens leave their sect behind, and the Middle East nonviolent revolutions, at the peak of standing up to the dictator, created that magic. As if an inexorable social law, the magic soon recedes. The constitutional aftermath seems incapable of capturing the moment to make it last. But it is the historic duty of constitution makers in the Middle East to at least make a serious attempt to solve or to attenuate the sectarian constitutional rhythm. Let me stop here. There is a third section where I'm drawing a little bit of these new windows, but I think you're tired. I can see that it has been going far too long, and frankly, I'm much more anticipating your question than listening to my own dull voice. Thank you.